Hello and welcome to another edition of our live immigration webinar series brought to you by immigrationquestion.com, where real immigration conversations happen and trusted attorneys bring clarity to complex legal issues. I'm your host, Anusia Mukherjee, and today's session is how to ethically manage sensitive personal data of your immigration clients. It's is one every immigration professional, attorney, or legal staff member absolutely needs to hear. Now, immigration law isn't just about filling out forms or chasing deadlines, it's about people. And when clients share their most intimate, often vulnerable details of their lives with you, you take one on more than a legal obligation. You take on an ethical one. In a time when privacy regulations are evolving and digital risks are growing, immigration professionals need to know how to manage client data ethically and securely, especially across border systems and jurisdictions. To guide us through this critical topic, we are honored to welcome today's guest, attorney Francesca Giannoni-Crystal. Attorney Giannoni-Crystal is a dual qualified attorney in the US and Italy with over 20 years of international legal experience. Licensed in New York, Washington, D.C., and Italy, she is a recognized authority on legal ethics, cross border compliance, and privacy. She has helped global companies and individuals navigate complex legal systems in Europe, Asia, and the Americas. And she also advises lawyers worldwide on issues on ethics, immigration law, and digital privacy. Attorney Giannoni Crystal, we're thrilled to have you with us today. Thank you for being here.
Thank you, Anusuya. Happy
you.
to be here.
Thank you.
So,
Go ahead.
see, I was saying that immigration attorneys manage sensitive data for their clients, so they need to take special precautions. However, the obligation for the immigration attorneys are not different from an ethics perspective from the obligation of the other attorneys. So there is a lot going on, especially right now with the use of the AI. So it's we will have only 20 minutes or 30 minutes, so obviously it's not sufficient for giving a complete overview of your obligations, but we can make some important points that could be important for dealing with your client's data.
Thank you so much for that, Attorney Giannoni Crystal. Before we get started, just a quick reminder. Immigration Question is a platform that connects users to licensed immigration attorneys. We are not a law firm, and nor are we affiliated with AILA or USCIS. All legal services are provided independently by attorneys registered to our network. So let's start with the questions. Attorney Giannoni Crystal, when it comes to immigration clients, what are the key legal and ethical considerations attorneys keep in mind when handling their personal data?
Yes, as I said, I mean, the obligations of immigration attorneys are the same as the other attorneys. We have to deal, first of all, with Rule 1.6 of the Rules of Professional Conduct in the version that your jurisdiction has adopted. And this is very important. And in a time of change, like the one that we are now today, with the use of the AI. So the obligation, the duty of confidentiality, and which is very much interconnected with the duty of competence in this particular way, should be always in mind when you deal with your data. And as I said before, immigration attorneys deal with a special category of data, sensitive data. Those are must be safeguarded more than general data. However, the confidentiality obligation of Article 1.6 applies to all everything that is learned by the attorney by reason of the representation. So the type of data that immigration attorneys have to deal with, it is only relevant for the safeguard, but not for the obligation. That remains absolutely the same. And basically, what do they have to keep in mind? I would say that a hot topic, as I said, is AI. AI is nowadays used by many lawyers, And I'm sure that many of the immigration attorneys that are now connected to our program benefit from the use of the AI. And it is absolutely ethical to use it, provided that you remember that you have a duty to safeguard the confidentiality of the obligation. So, the best practice would say do not insert confidential information of your client in platforms like ChatGPT, Gemini, or Claude, because independently from the level of contracts that you have, because confidentiality obligation, you have a duty to safeguard those. And however you can inquire into the level of safety of those platforms, there is always a level of risk. So you can do a lot with those platforms without necessarily inserting the data of your immigration attorney or your immigration clients.
Okay. Thank you for that. Now, in your work advising firms and attorneys, what are some common but often overlooked compliance mistakes law firms make in their day to day handling of sensitive immigration data?
In my opinion, one of the biggest problem is lack of training of your staff, because generally attorneys are compliant with their obligation. I mean, when I say Rule 1.6, everybody knows that, and everybody knows that they have to keep their information confidential. However, attorneys have also a duty to supervise both lawyers and non-lawyers that come from Rule 5.1 and 5.3. And sometimes attorneys forget about vendors. You have an obligation to vet third-party vendors for compliance with your confidentiality obligation. And among the vendors are, for example, cloud computing providers and AI. So never forget to establish clear guidelines inside of your law firm and to train your staff what to do with the client's data.
All right. For law firms, especially those that already have systems in place, how can they effectively evaluate whether their current data handling protocols truly meet today's standards for privacy and ethical conduct?
One, I would say, shortcut that you can use nowadays when you choose a vendor, for example, if you choose a vendor that is recommended by bar associations, then at least you have what you call like a plausible deniability. I didn't do nothing bad because my bar association recommends vendor X, Y, and Z, and that is the vendors that I chose. That doesn't mean that your obligations are diminished. You're still responsible, but at least I would say ethically you're fine. Of course, to get guards down, you must continue to be vigilant and being in compliance with the requirement. I could add that another practical advice that I always give my clients is get cyber insurance and be familiar with what the requirements of privacy of cyber insurance is, because it's useless to get a fabulous cyber insurance and do not comply with what are the requirements to maintain your coverage active.
Okay. Now let's get practical here. Could you share one or two actionable strategies that a solo attorney or a small law firm could implement right away to strengthen their data privacy protections?
Well, I believe, as I mentioned, cyber insurance is really a must nowadays. And the other one is having clear policies inside the law firms and be sure that everybody is absolutely on board with those policies. And I would say those must be updated constantly because, the TNCs, for example, of vendors change continuously. And so, if you did your due diligence and you vet your vendors 2 years ago, today the TNC of the vendors are different. So, be always vigilant that you maintain attention and you continue to vet your vendors and to do training to your associates. I've seen cases in which in um, in law firms, I mean, they were doing everything right, but then maybe they didn't instruct their summer associate about what were the confidentiality requirements that were imposed on everybody in the law firm, and that was the weak chain, the weak link of the chain, which is often exploited, for example, by hackers. I mean, you have to be very careful.
To our amazing audience, thank you for joining us. Whether you're tuning in from Facebook, YouTube, or LinkedIn, we're thrilled to have you here. We are immigrationquestion.com, a two-in-one platform built with lead and case management to help simplify the immigration process. Though we are not affiliated with AILA, we are trusted by a lot of AILA attorneys who use this platform. You can also ask your immigration questions for free in any language and get connected with a licensed attorney for guidance. You may also receive a free confidential initial consultation. Just visit www.immigrationquestion.com and sign up today. And some exciting news, we've just launched a new app built to serve both attorneys and users seamlessly. Attorney Giannoni-Crystal, as a licensed legal professional working closely with both documented and undocumented immigrants, how do you view the role of platforms like immigrationquestion.com in supporting and empowering the immigrant community today? In what ways do you think it adds value to individuals seeking legal guidance and trustworthy information?
I think every platform that inform immigrants of their rights and what are their possibilities are really welcome. I mean, it's important. At the same time, we have to be clear that the information that are delivered are not legal advice. They are delivered for information only, educational purposes only. So while the immigrants could get information in your platforms like in other platforms, it is always important that they double check the information with an authorized professional.
All right, thank you. Before we take live questions from our audience, let's widen the lens a little bit. Are there any global trends or standards in legal ethics or data protection that U.S. immigration attorneys should start paying closer attention to, particularly if they work with international clients?
I would say that data protection laws are becoming more and more common. I'm quite familiar with the European data protection regulation, which is the GDPR, because I advise on the GDPR law firms and non-law firms. I mean, the principle are quite. I mean, if you're subject to the GDPR, the system of data management in your law firms must change. However, you shouldn't run to implement the GDPR unless you are subject to. A common misunderstanding that I see is I'm serving the European market, I'm serving European clients, then I must implement the GDPR in my law firm. That is not the case. I mean, there are Article 3 provides uh, like cases in which the GDPR applies, which is not for every immigration attorney that serves European clientele. So you must have an establishment in the EU, and it could be minimal. You could have, for example, an office at your disposal in one European city, or you can have a colleague that allows you to share space with him when you go over there, or is authorized to subscribe clients for you. Then you become subject to GDPR, or you target the European market by specific advertisement for the European market. You say that you accept euros. That is another case. Or you monitor the behavior of European citizen. If you are in this situation, then you're likely to become subject to GDPR, and at that point, you're subject to principles like lawfulness of data processing, fairness, transparency. At that point, you need a privacy notice, and you need a purpose limitation of the reason why you are dealing with the data of your clients. I would say that exactly as the GDPR in Europe, in many other countries, data protection laws are becoming quite widespread, like Brazil and Russia and Japan and many other countries have data protection law. Of course, in the US, you don't have a generalized data protection law, but you have specific data protection law. So, for example, HIPAA, a lot of data that immigration lawyers deal with are subject to HIPAA or to the privacy law. You, in case of big law firms, you might have the California privacy law becoming applicable. And of course, you have data breach laws, in which if your law firm is subject to a data breach, you have to inform your clients, um, depending on the deadline of the data breach law to which you're subject. The deadline for informing the clients is different, but is stringent. So I would say that, in my opinion, one general global trend that you see around is more and more privacy laws that become part of your practice.
Thank you so much, Attorney Giannoni-Crystal. That was insightful and extremely relevant to the real-world challenges attorneys face every day. Now we'll move on to our live Q&A session. This is your chance to ask Attorney Giannoni-Crystal your own questions directly. Just type them in the chat or call us live on 516-703-3483. So the first question is, can I adjust status? Haitian 2023 Biden parole cut short. I-94 expired, but I have valid TPS, August 2025. Wife LPR filed 130 Jan 2025. Priority current. Medical done. Can TPS bridge adjustment?
Well, I deal with ethics for immigration attorneys. So this seems to be a question with its specifics. So I would encourage the person to get in contact with his immigration attorney of trust and to ask this question. This is not so much my field. I mean, I assist immigration attorneys to do their ethics requirement and privacy requirement.
Thank you. Next question is, how can small to mid-sized immigration firms build a cost-effective yet secure system to protect sensitive client data from breaches?
I would say that besides cyber insurance, as I recommended before, I would look on the website of the bar association of which you are a member and look for recommended vendor. So, for example, I would say cloud computing. Of course, big law firms have their own system, and that are proprietary. But I think there are wonderful vendors around in which, and you can trust, I believe, provided that you do a due diligence of their TNC, and you have to be, as the ABA has specified, for example, in opinion 512 on the use of the AI, you have, as an attorney, you have an obligation to perform a due diligence on your vendor and be sure how they use your data and what happens at the end when you don't use the service anymore. That is why I was saying that if you use one of the platforms recommended by the Bar Association, all this work is mostly done for you. I wouldn't say that you don't have an obligation to read the TNC. I will never say that, but you can rely on the opinion of the Bar Association about what it is compliant and what it is not.
All right. Next question is, what ethical and legal boundaries should we be aware of when government agencies request access to sensitive case files?
Well, this is a big problem, and the intersection between your legal obligations and a request from the government, you have the same problem, for example, in discovery. And those, of course, are mandatory disclosure. And of course, you have to resist. I mean, the first duty that an attorney has in front of a request for sensitive data is resisting the request, provided that you have ground for resisting. And I would recommend to inquire and to look carefully. Our law firm, for example, receives several requests for assistance in case attorneys receive a subpoena or request from the government for disclosure of clients' information, and they look for advice regarding their ethics obligation. Sometimes you have ground to resist, and sometimes, unfortunately, you don't. I would say that, of course, it's a lot, as my law partners that has written a lot about that. It's your philosophy of lawyering, that if you are more clients oriented, you're more protective of your obligation. I would say that most immigration attorneys are client oriented. I mean, are there to do the interest of their client. Everybody's there to do the interest of their client, but immigration attorneys are really on the first line to assist people in very critical situations. So I'm sure that they will do their best to resist the an overreaching on behalf of the government, if that is the situation.
All right, thank you. Our next question is, do you include any digital privacy clauses or cybersecurity disclaimers in your client engagement agreements?
Well, I include a technology clause, that for sure, and I explain which is the way in which I deal with the data of my clients, and actually I explain the type of encryption that I use, and I ask the client to specify whether they are comfortable with that or they require a special level of encryption. So for sure, I'm not so sure if I would call that a disclaimer. I would call it cybersecurity a technology clause, because you cannot disclose, you cannot really disclaim your duties. So you have a duty to protect, and you have to implement reasonable safeguards for the data of your clients. You're not an absolute guarantor of the safety of the data. What you are required by the by the ethics rules, is to take reasonable precautions. That is what it is, and I really, really recommend a technology clause in the engagement agreement.
All right, thank you. Our next question. What kind of cybersecurity or data handling training do you recommend for new associates and non-legal staff in an immigration law firm?
So I think, first of all, you have to have guidelines about what you can and what you can't. And inside the guidelines, I would recommend never to have the bring your own device on in a law firm. I know that that could be a temptation, especially during the pandemic. A lot of people were working from home, and they're using their own devices. That is really not a good practice. And of course, I recommend not sharing devices for with anybody, and provide the devices that are dedicated to your practice. If depending on the size of your law firm, it is also good to have periodic training that explain which are the expectations of the law firm. So I think if you are a medium-sized law firm, you don't even necessarily have to have the platforms with the training incorporated there the big law firms have. You can have something that is very simple. Could be an email that maybe circulate among all the new associates and summer staff. Now we are in the summer, so you have a lot of summer students maybe coming over, and so they might not know what it is. So I recommend clear guidelines and emails that explain what they should be doing.
All right. Next question is, how do you balance the convenience of cloud tools and AI assistance with the strict demands of confidentiality and data ethics?
Well, I'm a big fan of AI. I mean, I will never say that you shouldn't use it, but you must be careful, of course. And as I mentioned before, it is not necessary to insert confidential data in the use of AI. You can do a lot without using confidential data. Of course, cloud is another matter. I mean, I think for cloud, once you're familiar with the TNC of the clouds, and you vet them accordingly, and and you use reputable providers. I mean, of course, you are authorized to put the data of your practice inside the cloud, especially if those providers are recommended by bar associations. I think we have overcome nowadays the concern about clouds not being ethical. Now, of course, AI is another matter. And I personally would never input confidential information of clients in AI tools, not even proprietary tools, because sometimes you have inside a medium-sized law firm, you have attorneys that are screened for conflict. And if you insert data of your clients inside the system, then they might end up to be used by those attorneys that should not see those data. And I think you can, I mean, let me specify that with the consent of the client. Also, the ABA opinion 512 has said that you can also insert confidential data of your client inside AI platforms. I don't do it, and I discourage you from doing that, but it is possible, provided that it is an informed consent. So you explain to your clients the advantages and the disadvantages of using the AI and sharing your confidential information.
All right, thank you. Next question is, what should a solo practitioner do differently from a large firm in order to manage sensitive immigration data securely?
So, as a solo practitioner, you have more problems and less problems at the same time. Because, of course, you don't have the problem of training. I mean, you don't have to train anybody. You have to get familiar with your obligations, and you get, as comment 8 to rule 1.1 of the rules of ethics, the rules of professional conduct says, you have to get familiar with the advance of technology, the advantages and the disadvantages. You don't have to instruct anybody. On the other hand, of course, probably as a solo practitioner, you don't have the possibility of investing in big proprietary platform. I think there are a lot of reputable vendors that you can use, and again, I would encourage you simply to be careful to read the conditions for services periodically. And if I have to say, and I say that to everybody who would listen, get a cyber insurance and be sure what it is covered and what it is not, because it is peace of mind, in my opinion.
Definitely. Next question is, what are your three must have policies or tools every immigration law firm should adopt today to ethically manage client data?
Okay, I would say the first one is getting familiar with the new technologies that you want to use. I mean, you might have the temptation to use the newest technology, but you have to see if it is appropriate to your law firm and to the type of data that you use. As an immigration attorney, your level of, the data that you're managed are the most sensitive. I mean, also under the GDPR, those are special category of data, and they deserve the highest protection. So be sure what you use. So know what you do. I would say tools. My opinion, AI is a great tool, and while you're not required to disclose to the USCIS the use of AI, it is quite known that the USCIS is using actually AI to actually review the applications, and they use that to spot anomalies. So be sure to use the same, do in a smart way. Don't put your confidential data of the confidential data of your client on the platforms. But I would say use that, and third, I would say be sure to train everybody that happens to be in your firm, either on a permanent basis, like your paralegal, or on a provisional basis, like the summer associate.
All right. I think that is all the questions that we have. So that was a highly educative session. Thank you so much for joining us, and a special thank you to our special um, guest, Attorney Giannoni-Crystal. We've gotten a lot of positive comments as well. Somebody said great presentation. We had some important points and a
Thank you.
thank you. So thank you for your practical and strategic insights. We hope this webinar helped answer your questions. Remember, at immigrationquestion.com, you can ask your immigration questions for free and get connected with a licensed attorney in good standing who can help you better understand your options. You may also qualify for a free confidential initial consultation. Visit our website to learn more. Don't forget, you can rewatch this session or listen to previous episodes on Spotify. Just search for Borderless Talk by immigrationquestion.com. Join us again on Wednesday for another enlightening edition regarding another burning immigration topic. Trust us, you don't want to miss it. Once again, thank you so much, Attorney Giannoni-Crystal, and we look forward to having you back soon.
Thank you, Anasuya. It was a
Thank
pleasure.
you.
Bye bye.